be seated. Good afternoon. Welcome to the First Court of Appeals. We have one case on the docket this afternoon. It is 01-2400674CV. Starting with appellant, counsel, please make your announcements.
My name is ROSA. I represent Houston Methodist Hospital, Dr. Himanshu Potter, and Dr. Okechukwu Okidi.
Thank you, Mr. Rosa. Appellant?
My name is IESHA and I represent the appellee, TAMMY GARNER, as an individual and surviving mother of decedent Julius Garner.
Thank you, Ms. Wells. Each side will have time for argument. Have you decided how you're going to allocate your time?
Yes, Your Honor. I'd like to reserve at least 5 minutes for rebuttal.
Yep.
And I'm going to try to be as brief as possible.
Yes, and I think the clock says 15, but I think the letter that was issued indicated you would have 20 minutes for argument. Can we move the clock here? Wait, 5 minutes rebuttal? Okay,
yes,
got it. Okay,
at
thank
least.
you. Yes. And before we begin, just some housekeeping matters. So you have the lights here. Just when the light is red, you may go ahead and finish your question. And of course, if we still have further questions, we'll let you know if we want to continue the argument past that time. We have read all of the briefs and we're very familiar with the facts of the case. So we don't need a full recitation of the facts at this point. It would be the most useful to us if you can go ahead and start diving into the legal issues here. I know here we're dealing specifically with some procedural matters. Specifically, we have to determine whether we have jurisdiction over this appeal. And the question the parties have presented is whether a deficient report was presented or no report was presented at all confers jurisdiction on the court. So if we can start with that, that would be very helpful to the court. Mr. De La Rosa, you can proceed.
Thank you, Your Honor.
May it please the court, thank you for hearing our appeal today. This is a case that included 15 total defendants. That's a big number. Because it was a healthcare liability claim, an expert report was required. But with 15 total defendants, a large number, the plaintiff struggled to articulate a theory of liability against each one. The expert report she provided failed to implicate all the defendants, including my clients, Houston Methodist Hospital, Dr. Potter and Dr. Okidi. Because it did not implicate them, it was no report at all.
Counsel, are you saying that the one expert report that's before us in this case was the only expert report filed as to all of the defendants, or were there other expert reports for the other defendants?
I believe it was the only one, Judge, but it's the only one that's the subject of the appeal.
Fair. Okay.
You asked about jurisdiction. When a document constitutes no report and the trial court grants a 30-day extension, you have jurisdiction. The jurisdictional question turns on whether the document is so lacking in substance as to constitute no report versus something that can be cured.
And I think what would really help us is to determine, because I agree with you, that we have to determine whether there's no report at all versus do we have a deficient report. I think, can you articulate for us what you think our standard is in reviewing or making that assessment? And what is your best case to support what you think our review of the report would be to make that determination?
Yes, Your Honor, I have a handful of cases. But to answer your first question, the standard of review. Ordinarily, it would be abuse of discretion. But we have a statute here. There's a statute that tells you whether a document is an expert report or not. And when you're interpreting a statute, then the standard is de novo.
I think, and maybe I didn't state my question very clearly. So I know we're not reviewing the sufficiency of the report on the merits. And we're definitely not reviewing the decision to deny the motion to dismiss on the merits. What we're really trying to determine is whether the report was deficient. As I understand it, Scoresby sets the standard for us to review whether the report was sufficient, and that standard, as I understand it, is very lenient.
It is, Your Honor, but it's still a standard. And what it requires is that the 3 required elements from the statute appear in the report. That's why I attached the statute to my brief. It's Exhibit C. And we can look at it now. It's,
Well, before you go there, where does it say, or what case says that we have to look to make sure that all three requirements are in the report for purposes of our sufficient analysis here?
Scoresby, Texas Supreme Court, 2011. The history of that is that this very standard was first identified 4 years prior in the Ogletree case in a dissent by Justice Willett. In that case, the court basically ruled that any paper with words on it from a doctor can be cured. It was extremely lenient. I mean, there was no standard. But Justice Willett was worried about that, and he said, wait a second. I think it's possible, he called it a rare bird, it's possible in rare cases for a report to be so lacking that it doesn't count. In order to decide whether it's lacking or not, we look at the three required elements from the statute. That's in Justice Willett's dissent in Ogletree. Now, 4 years later in Scoresby, the Texas Supreme Court picked up on that dissent and adopted it wholesale and made that the law of the land in Texas.
Well, I'm looking at the specific standard that was articulated in Scoresby, and I'm looking for your benefit at pinpoint 557. And Justice Heck there says, we conclude that a 30-day extension to cure deficiencies in an expert report may be granted if the report is served by the statutory deadline, that happened here, if it contains the opinion of an individual with expertise that the claim has merit. I know you have issue with that. And last, if the defendant's conduct is implicated. We recognize this as a minimal standard.
Yes.
All deficiencies, whether in the expert opinions or qualifications, are subject to being cured before an appeal may be taken from the trial court's refusal to dismiss this case. And I did read Justice Willett's concurring opinion, but I don't see where those three elements are re-implemented in Scoresby.
Yes, Your Honor. The case discusses the Medical Liability Insurance and Improvement Act, and it says that act defines what requirements a document must have in order to qualify as an expert report for purposes of Texas Civil Practice and Remedies Code, Chapter 74. And then it quotes the statute. So that's where it appears, Your Honor.
But does that apply to the extension issue, or just whether the general standard for a report?
It has to be a report in order for an extension to be proper. If it's not a report, it's the same as if there was no document served at all.
So you have to file a sufficient report in order to get an extension to cure a sufficient report? I mean, I'm just trying to understand this.
Yes.
How I'm seeing it is Scoresby lays out what Justice Rivas-Malloy just read to you is the standard when we're looking at whether the extension was proper or not. And that's really what needs to be met. I mean, where am I wrong on that?
Basically, Your Honor, there are three kinds of reports. There's a good report, there's an insufficient report, and there's a no report. And I believe Your Honor may be conflating the insufficient report with the no report. Some insufficient reports are no report. Some insufficient reports can be cured. And the difference is whether the three required elements from the statute appear in the report.
What is your best case on the no report category that we can rely on, under which you would prevail? Because I do
under
agree
which
with
my
I do agree with you with those three buckets.
Yes.
I think maybe the difficulty that we're having is how do we go into the no report bucket versus the deficient report bucket? And if we're in the deficient report, just the standard. So what is your best case for why this scenario and the facts here is a no report case? Why it falls in the no report bucket?
There are several cases that mention the statute and say that the statutory requirements have to be in the report. They have to be met to be a report. That's repeated throughout the cases. So I include Scoresby, I include Rivenis versus Holden, and I include Thomas versus Torres.
Counsel, some of the cases talk about an objective good faith standard, and granted, this is not 100% clear cut in the precedent, but there is some evidence, including, in our opinion, in the Mangin case, that the objective good faith standard is something that must be met in order for a report to qualify as deficient rather than no report. What's your opinion on that? Do you think that the objective good faith standard must be met in order for the trial court to grant a 30-day extension? Or do you think it's a test for whether a report is adequate and it doesn't play into the deficient versus no report analysis?
If I understand your question correctly, Justice Dockapel, I don't think that those are two different things. I think that if a report doesn't have the statutory requirements, then as a matter of law, it's not a good faith report. If it does, then it is. Let me tell you the most common type of deficiency that I see, and this has been my practice area for more than 30 years, and that is when the opinion is conclusory. If the opinion is there's an opinion that addresses the required elements, but it's conclusory, there's not enough discussion. I'll object to see if the expert can flesh that out. That is always curable, always. And in my motion to dismiss, I had 4 objections. 3 of them had to do with curable deficiencies. But the most important one, and the first one, was that the report didn't implicate my clients in the first place because the statutory elements were not in there. This is a relatively straightforward and simple analysis. There's only 3 required elements. They go back to first year in law school torts class. We all remember what are the 4 required elements of a tort: duty, breach, causation, and damages. In a medical case, duty is really never an issue. If your name is in the medical records, you have a duty to the patient.
Mr. De La Rosa, and you can help me with this, and I appreciate your experience in this area. Maybe you can be helpful to us in that respect. The appeal that was taken here is an interlocutory appeal, and unlike other interlocutory appeals, this statute expressly states which interlocutory appeal may not be taken when a motion to cure has been granted. If the standard that you're asking us to adopt is to review in every case in where an extension has been granted and an interlocutory appeal is taken, that we have to evaluate the report for all those 3 elements, are we not eroding and writing out of the Civil Practice and Remedies Code the express provision that states that you cannot take an interlocutory appeal from a motion from the granting of an extension to cure? That's where we're coming from. So if you can help us with, because we're having this tension between our ability to review a report where the trial court has granted an extension and the express directive from the legislature that these appeals are not to be taken on an interlocutory basis.
Your Honor, that's a valid concern, and the first point I would make is that hasn't concerned other courts that have published these opinions that we're relying on. And I'm not asking you to make new law. I'm asking you to follow the law that's been the law ever since Scoresby in 2011. Let me also state that my other 2 cases that I heavily rely on, Rivenis and Thomas, they're Houston cases, 14th Court, 2008, and 2011. So this is not groundbreaking. I'm not asking you to change anything. Your concern is a valid one, but if it didn't concern any of these courts, it shouldn't concern you either.
Well, Rivenis and Thomas were both decided before Scoresby, so this is where my concern is, that I appreciate that these courts directly address this issue. They unfortunately did not have the benefit of what is now precedent for us in this court in evaluating the issue that is before us.
And I'll tell you where I'm really coming from. If you look at L in the statute, L, that gets into the adequacy of the report, and if it represents an objective good faith standard to comply, then you deny the motion to dismiss. To me, that's separate from C, which is you get a 30-day extension. The court, has a discretion, the trial court, to grant a 30-day extension. Nothing in C talks about an objective good faith standard or that the 3 prongs of subsection R6 need to be met. It just gives the court discretion. So then what is our standard? You look at Scoresby, and really does it implicate the defendant? So how does the expert report in this case not implicate Potter when it mentions him several times in there and talks about what he did during it, and talks about that a fire broke out, when he was using a cutting tool near the trachea? How is that not implicating Potter enough for the court to exercise its discretion to give them a chance to cure this?
The answer to your question, Your Honor, which is a good question, appears in the Thomas versus Torres case. In that case, the physician's assistant was in an analogous position to Dr. Potter. She was mentioned by name 3 times in the report, but only in passing. Just like this report, that report did not identify the standard of care as to her. It did not say that she breached the standard of care, and it did not say that her negligence caused any harm. Same thing here. Dr. Potter is mentioned in passing, but the standard of care is not identified. The expert talks about how he made an incision close to the sternal notch. She doesn't say that that's not the standard of care. She doesn't say he shouldn't have. She doesn't say that was negligent.
But don't you think that's something they could cure? It's curable, potentially?
Under the case law, it can't be cured if it's not in there in the first place. She had to say he was negligent.
But if he had already said that, then they would have met the report requirements, so there would be no reason to cure it. It'd be a sufficient report.
No, not if it was conclusory, Your Honor. And that's what happens in the majority of the cases, is the opinions are too conclusory. What will typically happen in an objectionable report is that the expert will just make a leap. Usually because the plaintiff attorney tells the expert, hey, look, you got to say X, Y, and Z. It's just a procedural requirement. They say it, and they move on down the road. It's usually conclusory, and that could be cured. But if there's no conclusion in the first place, there's nothing to cure. And that's what the case law says. You have to meet the 3 required elements of the statute in order to have something to cure in the first place.
Okay, but counsel, like, the expert report does say that the cause, if you read it charitably, which I think the trial court was trying to do in determining whether or not it was deficient or no report, there's an explanation of how the fire started. There was electricity near oxygen, and it caused a fire because it lit paper on fire. And
I can address that.
okay, yeah, it just seems like taking the trial court's perspective for a minute, which we do have to do for abuse of discretion, that there is an effort to do standard of care and implications. So where's the line for us between opportunity to cure and falling too short?
With all due respect, Your Honor, the way I read this, there's no effort to identify the standard of care or say that Dr. Potter breached it. I know what you're talking about in the expert report. It says the procurement surgeon, that's Dr. Potter, started the sternotomy within close proximity to this tracheostomy tube. This resulted in a surgical fire. It does not say that that was negligent.
And you don't think that a fire, how do we deal with the fact that there was in fact a fire? I mean,
remember, there are 15 defendants, all right?
Mm-hmm.
Everyone has a different role.
okay.
Every defendant is entitled to the protections of Chapter 74, which means they get a report as to them that says what their standard of care was, that says, even in a conclusory fashion, it can be cured, that says that they were negligent. This does not say Dr. Potter was negligent. That is the fundamental basis of an expert report. How do you know that the case has merit if the expert can't even write that the defendant was negligent?
Yeah, I mean, I think there's no question that the report is deficient. I think we're just trying to determine the scale as to what level of deficiency would trigger our ability to review this on appeal.
There has to be something to cure in the first place, meaning there has to be an opinion that's deficient. If the opinion itself doesn't appear in the report, and there's no negligence opinion here, there's also no causation opinion as to the negligence. The expert says that...
and it'll help you. I know we're out of time, but maybe in rebuttal you can address this. If I remember correctly from the Scoresby decision, the standard of care was not mentioned in that report.
That was a qualifications
Yet the
case.
trial court... yeah, you can answer that question for me if you want to take your time to rebuttal. But if I remember correctly in Scoresby, the standard of care was not elicited or mentioned in the report, and yet the court found that it was entitled to be cured.
Different facts, Your Honor. The sole objection in Scoresby was the qualification of the expert, not the standard of care opinion in the report.
Oh.
That's the difference. Specifically, Your Honor, in Scoresby, the expert was a neurologist. The defendants were ENT surgeons, ear, nose, and throat.
Okay.
That was the sole...
So the issue there, because had they objected perhaps on the standard of care, was the qualifications issue, because the qualifications were presumably colorably there.
That could be cured.
That could be cured.
Arguably. The expert gets a chance to cure it by saying, yes, I'm not an ENT surgeon, But here's why I have expertise that would help the court. And that's how you cure it, and that's allowable. A 30-day extension to fix that is allowable. What you can't give an extension to fix is when the report doesn't have the opinion in the first place. Because if it's not there, there's nothing to cure. And the extension is not intended to give the plaintiff a new chance to submit an original opinion. It's supposed to be a revision, a refinement, an explanation, a curing of an opinion that already appears there.
And your best case for
not
that?
even there.
And your best case for that's to the Torres?
Rivenis and Thomas versus Torres.
Thank you, Mr. De La Rosa.
Thank you, Your Honor.
Ms. Wells, when you're ready.
May it please the court. Diving into your question specifically about the standard, our position is that when we're going into the standard about a report, and if a report is deficient compared to no report, is how you were saying about the fair summary, the standard care failed to meet the standard casual relationship. In Ogletree, though, it does say that not all initial timely reports have to satisfy each of the statutory criteria. Right, if there's some things missing or something that can connect causally, that is what the 30-day cure was meant to do.
So what is the standard by which we evaluate the deficient report in this case?
I would, good faith plus the fair summary. I would say good faith to inform the defendant of specific conduct. That's Regent Health also talks about that. Provides basis to show plaintiff's claim has merit.
And what case do you have for that? Which case are you relying on for
So
that
Regent
standard?
Health Care.
Do you have a cite for that? Or was it cited in your brief?
Yes.
We'll get it.
What year and what court?
Texas Appellate El Paso, 2008.
Counsel, your brief also relied on the Texas Supreme Court's decision in Miller versus JSC Lake Highlands, correct, for the standard of good faith?
Yes. Also, we have where we're talking about kind of the difference between what we're saying and what the opponent is saying about that standard. And it seems that the standard he's trying to do is what the courts were trying to deter, right? The courts are not saying that everything has to be perfect, every standard, everything has to be met. It's just saying it's trying to deter frivolous claims and not to dispose of claims regardless of their merits. And how you guys were saying before in La Sago v. Cerner, it says there is a low threshold.
How do you distinguish Thomas versus Torres and Ravines, which is the cases on which Methodist Hospital and the doctors are relying?
Yes. So when it comes to Thomas in that one, it did not name the defendant or the conduct. And even within the language of that, the court ended up saying that the report for Dr. Thomas was deficient. The general statement of standard of care can be construed as applying. So they did a general address of conduct and not specific. Also, the court stated in Patel that you don't have to use, in Russ v. Titus and Patel, that you don't have to use magic words. So because within the report we didn't use these magic words of negligent, standard of care, those exact words, does not mean that report was not.
It's not, from what I'm understanding the appellant, it's not the magic words were not used, it's that those elements were not addressed at all.
Okay.
So maybe you can point us to the report and walk us why you think the three elements, standard of care, breach, and causation, were referenced in the report, if that were in fact the standard.
Yeah, so when we're going to the beginning of the report, she breaks down what needs to be done, what they're saying to stop or prevent the surgical fires, as it being specifically the triangle is one of the things that she uses and reflects back to when talking about Dr. Potter, the oxygen versus ignition versus fuel. Also talking about specifics about the communication, the timeouts, certain sessions, certain checks that they're supposed to do before starting, and even during the procurement, what they're supposed to do. So she starts that off with what could be construed as the standard of what you need to do, what things need to be happening. And then she goes into this case, so she applies it. She's saying, in this case, this is the things that happened. She speaks and then touches back consistently about the oxygen, the ignition, and the fuel. She talks about the anesthesiologist and the different percentages and what the percentage is supposed to be compared to what it is throughout the procurement. She talks about the ignition. Specifically, important thing is the cuffed versus uncuffed tube, right? And the cuffed versus cuffed, which may or may not, are tighter hold on the ventilation versus the uncuffed, which is more a possibility that the ventilation or oxygen could get around to that area. Then specifically goes into the request of Dr. Potter and the things that Dr. Potter does, as well as the surgical team. Well, really, actually, I'm sorry, reverse, let me do the language better. Well, really lack thereof what they did in this instance. Not necessarily what they did do, but the things that they didn't do that they should have done. Again, circling back to the timeout. So then again, the sentence that we were reading before, as you go into, she says, like, there are several factors that go into, like, what happened and how it got, how the decedent was set on fire.
So your position is that that report meets all three elements, although albeit deficiently, so that you were granted an would you agree with Mr. De La Rosa's statement that in order for have the opportunity to cure, you have to at least reference all three elements that are required?
Yes, at least reference, yes. At least reference. I just don't agree that it has to be specific words. I don't agree that all things, like if we're talking about a lot of things that were listed, was like the name was not in there. I don't think that that is the standard that the reports were meeting, and there are multiple cases, specifically in, like how we said, Thomas did not name the actual person, but then they still found it was deficient. Like you were saying in Ogletree, the standard of care, they notated that the standard of care was not there, but the support was still sufficient. When you go to,
can you walk us, why was this report a report at all as to Dr. Okiti? He was not referenced. It's very unclear to me what, if any, role he had based on the report. And as you know, the trial court was limited to the four corners of the report. So explain to us why, as to Dr. Okiti, this was a report at all.
So, and our position is more towards, again, not doing the name, but specifically the position and the conduct. So our position is when they're speaking of Okiti, who was the assistant surgeon under Potter, that when referencing the, again, going back to the original things that they said needed to be done with the communication and the timeout, when it speaks to the operating room team and surgical team, that is referencing Dr. Okiti.
Well, let me tell you where I'm seeing this. I can see, under the Scoresby standard where Potter is implicated here, but Okiti, I'm having a hard time finding. The first section you just talked about, dealing with the surgical team and stuff, this isn't talking about specifically the team that was operating on the decedent. This is just talking about a standard among surgical team members. So then when you get down into the actual facts part of the report, I see where Life Gift is mentioned. I see where the organ procurement organization is mentioned. I certainly see where Potter is mentioned. Where in that part of the report is Okiti ever implicated at all?
Right, his name, I think that's kind of where the deficiency and where the trial court was being lenient in regards to specific roles of people like Dr. Okiti. But currently our position is about the surgical team and the operating, and when it goes into the communications of the team members with the timeout sessions and the other sessions they're supposed to have throughout, and him as the assistant surgeon.
But maybe the issue here is not just that he was not mentioned by name, is that there's no identification into what his role was, where he would fit. To Justice Johnson's point, there were many people, I imagine, in that surgical room. There's no way, if you're Dr. Okiti, you're trying to defend against this report, there's no notion of what he did wrong, when, how, or why. So where, other than not referencing by name, where in the report does it allude to his conduct? Right.
Besides what I mentioned, I don't think there's anything that like specific besides what I mentioned.
Counsel, I want to go back to the standard for a minute, because on the one hand, you seem to be saying that the standard is the Scoresby standard for the basic elements of an expert report, that all three of these things need to be suggested to get an opportunity to cure. But then you've also said that the standard is an objective good faith test, which is different. That's two different prongs. The prongs are, they're sort of interrelated. They both have the prong of sort of implicating the defendant. The objective good faith effort test says you have to inform the defendant of the specific conduct and provide the basis for the trial court to conclude the claims have merit. So how do you see these two standards as connecting in terms of saying that a report is enough of a report to be entitled to a 30-day extension to cure?
I think they relate because when you're going into the specifics, say the fair summary, the standard of care failed to meet the standard in the causal relationship, it has to be, when you're going and laying out those things, it has to be enough that it informs the defendant of the specific conduct. So whatever language that you're using to present the standard of care and failed to meet the standard in the relationship has to be enough to inform the defendant and provide a basis to show that the claim had merit.
So would you say that's a threshold test? And let's say you have a deficient report that doesn't satisfy the objective good faith test. Should it have an opportunity to cure?
I would say no.
Okay.
Trying to think of other things. Also just thinking of the other things that he said when we were going to, I know what was also brought up was Justice Willett and his distinction about the absent versus deficient. It seems that when we're going in this briefly, he said he wants to be clear. He's not describing a situation where elements of the report have been found deficient, thus making the report eligible for opportunity cure. Rather, I'm describing a situation where elements of the report have not been found at all, where the plaintiff submits nothing but doctor or provided signed material that contains zero or practical zero decisions of what makes a report a report. Elements must be present to be labeled deficient. There's non-existent, there's no report. I put that also in my brief because I think that we meet that threshold that Willett was trying to say. He's not saying reports where there is stuff there, where there are elements there for it to be cured, because again, that's what the courts, what you guys were describing before, wants. That's why we give that opportunity for that 30-day extension to cure when their elements are there and the elements exist. As I was stating, I feel like the elements do exist in this as we were running through talking about the standard, and it goes into the things that could have been done with the tube, with the oxygen, knowing where Dr. Potter started his incision, where he could have. And it also states that within it, after the fire was done, or I guess they tamed the fire, that they reconvened, did what they had some sort of session regarding what needed to be done, and after that there was no other fires or incidents after. So after they did what the standard or what the expert felt needed to be done or should be done as a standard, there were no more incidents continuing, and they were able to take out the organs that they wanted to take out.
Are the appellants the sole remaining defendants left in this lawsuit?
I'm sorry?
Are the appellants the sole remaining defendants left in this lawsuit?
Yes. And we did not mention it, but also just to go through when we're talking.
Has the amended report been filed?
No. When going through, because I don't know if you touched bases, because this is my time, about Methodist, because again, it may be the same argument that they were not named, nor their position was put in the report, but we claim vicarious liability when it comes to Methodist, and we have the main gen, we have Denton University, and they're all named within my brief. University of Texas Medicine Branch versus RailSAC, and University of Texas Southwest Medicine Circle and Dale, where they talk about that you can establish negligent conduct. You can establish negligent conduct of the employee, and vicarious liability then latches on. And it says even if you don't name that hospital, or even if you don't name them specifically, if you can tie that connection, you don't have to mention the hospital when it comes to vicarious liability for employees.
Well, I understand there were vicarious liability claims made against the hospital. Were there also direct claims made against Methodist?
Thank you. I think we did come direct as well, yes.
And so the argument that you're raising is because Methodist was not referenced, the claim as to Methodist would survive based on vicarious liability. how would it survive as to Methodist based on any direct claims, given that they're not mentioned, and the report doesn't really address these three elements as to Methodist?
Then I would say, if it's just based on the direct liability, it would only be if we're going back to the conversation about position versus name. But I feel like if we're only, it would be for vicarious more than general.
So you would agree that the report was deficient as to the direct claims against the hospital?
Yes. I do and have said that deficient, with the case law and with what the report, I don't think it's considered a no report or absent report.
Oh, well, I'm glad you're clarifying that, because that's what I was really asking. So you don't, with respect to the hospital, because they were not referenced and there are direct claims asserted against the hospital, are you saying that you don't believe there was a no report at all? How was it deficient then? Because Methodist is not referenced, and there's no indication as to how Methodist would have been negligent. The surgery was not at Methodist, it was at Texas Children's Hospital. So help us explain why Methodist is implicated as to any direct liability against the hospital.
For vicarious, it would be because it's undisputed that
Right, not vicarious.
Oh.
Just, I follow you on vicarious.
Mm-hmm.
I'm talking about direct liability toward any direct claim against the hospital.
Direct claim. I'm not even 100% sure if we did direct.
So you're thinking there might not have been direct claims, is what you're saying?
Yes, Your Honor. That is correct. I would have to go over and confirm. Am I able to leave here and grab
Of
something?
course. Ms. Well, maybe I can help you this way. Assuming that there was a direct claim made against Methodist Hospital, why does that claim survive, given that Methodist Hospital is not referenced by name in the report and there's no indication as to what the standard of care or how they breached that standard of care in this case?
Yes, if it was direct, and it looks like what we claimed was negligent hiring, training, monitoring, supervision, retention against the defendants, it would lean towards that, because Dr. Potter, as an employee of Methodist, was negligent when he did not make sure the oxygen was the levels where they were and continued and caused the fire.
That was with respect to Dr. Potter only, not to Dr. O'Kitty? It was Dr. Potter only who was affiliated with the hospital?
Within it, we claimed just the employees. We didn't specify.
Oh, the employees, thank you.
Just to wrap up, and we feel like We wish that you affirm the decision of the lower courts, that our report meets the standard of being, at the bare minimum, a deficient report, and it has the standards and information to connect Dr. Potter and Methodist and Dr. Akiti to the incident that occurred for Julius Garner. We feel that our cases, as well as the Scoresby standard that you mentioned, as well as the other ones I mentioned previously, confirm that, and confirm that, again, it doesn't have to have these magical or set words. Again, even if it doesn't have the name, if it has the position, and it generally connects or casually connects to the incident from the actions taken or not taken from the defendants, that it should at least be considered a deficient report. Thank you.
Thank you, Ms. Ross. We're ready to hear appellant's rebuttal.
Just 3 points. Your Honor's asked me several times, what is my best case? I'd like to be even more specific. My best case is the Rivenous case. And I would direct your attention to the last sentence on page 338, carrying on to page 339. It tracks the required elements of the statute. It says they were not met, and says, therefore, we hold that Lamberg's expert report does not implicate appellant's conduct, and thus is not a report as to appellant.
But it's pre-Scoresby, correct?
Pre-Scoresby, but post-dissent from Ogletree, which is the very framework that Scoresby adopted. Point number 2. Although Dr. Potter is mentioned, it's only in passing. And under the Thomas case, that's my best case for the authority that mentioning someone in passing isn't enough. You still have to have the required elements. There was a physician's assistant in Thomas that was mentioned 3 times in the report, but the required elements weren't there. So it was no report as to her. That's my best authority on the fact that he was still mentioned. Then finally, my motion to dismiss that the court ruled on. I had 4 objections. 3 were curable and 1 wasn't. The one that wasn't was what we're here about. The fact that the report didn't have the required elements of the statute and therefore didn't implicate any of my clients. The other objections were curable.
Do you concede that Drs. O'Kitty and Potter are agents or employees of Methodist?
They are employed by a corporation called TMH Physician Organization. It's not a party to the suit, and it is affiliated with Houston Methodist, but it's a Texas corporation, as is Houston Methodist. In other words, they're not the same company, although they are affiliated.
Well, I guess the question is, if we were to conclude that the report was curable as to Dr. O'Kitty and or Dr. Potter, then that would also suggest that then it was sufficient as to Methodist, at least on a vicarious liability theory.
Well, Dr. O'Kitty wasn't even mentioned, but yes, Your Honor. As to Dr. Potter,
either
yes.
Or, one or the other. Okay.
The answer to that is yes.
Okay.
I'm sorry.
No, go ahead. I'm sorry.
Were there direct claims against the hospital?
Your Honor, this surgery happened at Texas Children's.
Right.
It didn't even happen at Houston Methodist. The petition might not have been the best drafted, and so it could be ambiguous, Your Honor. I don't remember any direct claims against Houston Methodist. The surgery didn't even happen there.
And I just want to make sure, Justice Weaver-Malloy, this question, I got your answer direct. If we determine that it's sufficient as to Potter and or O'Kitty, you agree that it's vicarious liability then as to Methodist?
I agree.
Okay.
Thank you. Thank you very much. I appreciate it. Thank you both sides for your arguments today. The case is now submitted and we are now adjourned.
Thank you, Your Honor.